Selamat sejahtera. We from Group 3 want to present about debenture, the effect of Kim Lin case and the establish of Dana Harta and corporate debt restructuring committee. Okay, firstly, my name is Muhammad Arif bin Ahmad Bezowi. My number matric is 2735598. First of all, introduction. A debenture is an unsecured mortgage or other lending instrument with no collateral. Since debenture lack collateral, they must depend on the issuer credit worthiness and prestige for protection. Debenture are frequently issued by companies and government to collect money or fund. A debenture is a financial instrument that is not secured by any asset and any usually has a period of more than 10 years. Debenture, like most bonds, can incur periodic interest payment known as coupon payment. Debenture among most forms of trust are documented in an debenture. Debenture may be issued by both corporation and government. Long-term bonds, those with maturities of more than 10 years, are the most common form of bond issued by government. These government bonds are considered low-risk portfolios because they are backed by the government issuer. A trust indenture must be drafted before the debenture can be issued. The first trust is a contract between the issuing company and the trustee that handles the investor's interest. Companies benefit from debentures because they have lower interest rate and longer maturity terms than most forms of bond and debt instruments. Debenture can be subject to credit and default risk. Our scope of research is examining the evolution in the law in regard to the receiver and manager power to sell a land paid under the NLC, especially in light of the Kim Lin decision. We also look at the effect of the Kim Lin case, established of Dana Harta and corporate debt restructuring committee. Both debentures are structured in the same way and have the same functionality. It is unsurprising that in subsequent situations, efforts have been made to differentiate and circumvent the Kim Lin situation in the hope of avoiding the NLC rules and reviving the former tradition of private treaty by invoking the right of sale granted by the NLC. A debenture power of attorney or any equivalent document may be used to do this. The first step is to formulate a trust indenture, which is an arrangement between the issuing company and the entity that handles the bondholder right. The coupon rate or the interest rate that the corporation will pay the debenture holder or creditor is then determined. Debenture will now be issued for cash or in exchange for something else. The Kim Lin ruling in particular was a setback for the bank industry. This is because it has made some debenture power ineffective, most notably the right to sell a land paid under the NLC by private treaty.
Hi, my name is Norafika binti Hashim and my metric number is 2677741. Okay, I will talk about my part is problem statement that stated in the Kim Lin case and also the establishment of Dana Harta and Corporate Debt Restructuring Committee, or can be said as CDRC. When a borrower wanted to default on a payment of a loan, the bank has to exercise its right to recover the loan through formal or informal method. If a bank has created a debenture, they can appoint a receiver in order to sum the assets of defaulting the borrower company. However, a right of debenture holder had been initiated by the new development in the case of Kim and also the establishment of Pengurusan Dana Harta Nasional Berhad and the Corporate Debt Restructuring Committee, or can be said as CDRC. There are many kinds of effect that causes in the case of Kim. Firstly is the liquidations on the appointment and agency status of receiver. Under the National Land Code of this kind of case, the chargee has no right to sell the landed charge by a way of private treasury, but it must resort to judicial sale and cannot be contracted out. But under Companies Act 1965, under Section 223, any sales of land of receiver must be persuaded to debenture would require. The next effect is far-reaching. Why is far-reaching? Because far-reaching, it will apply the receiver and the manager ability to appoint a deal with and or dispose of landed security under debenture. The next one is establishments of Pengurusan Dana Harta Nasional Berhad and Corporate Debt Restructuring Committee, or can be said as CDRC. Why have they been established? Because Malaysians have faced a financial crisis in 1997. Therefore, the government created this both company in order for the Malaysian in order to restore the stability in banking sector and also to facilitate the restructuring of the large company that is stated in Malaysia.
Assalamualaikum and good morning to my doctor and my fellow friends. My name is Imran Kebabe Abdul Latif. My matric number is 266111. Today I will present about literature review of the Kim Lin case. A landed property or landed estate is a property that provides income for the owner without the owner having to perform the estate's actual job. Landed property was an important part of feudalism because it opened the landlord up for such activities such as government administration, military duty or application of law. Later, the dominance of landed estates as a foundation for public service won. The development of manufacturing and trade provide capitalist ways of gaining money, but they usually required the owner's attention. In 1997, the Supreme Court in Kim Lin Housing Development Sdn Berhad versus Bank Bumi Putra Malaysia Berhad and Ors laid down two important principles. To begin, under the National Land Code (NLC), as no charger can grant power of scale on a chargee by debenture, power of attorney or otherwise, but the chargee must initiate proceedings to procure a judicial sale in compliance with strict protocol outlined in NLC. Second, the liquidation not only ends a receiver and manager's agency for the firm, but it also ends his power on winding up, so there is no estate for receiver and manager to handle. Prior to Kim Lin's situation, it was widely assumed in Malaysia that receiver and manager named under the terms of debenture had the power of sale conferred by the debenture, in addition to and irrespective of the powers conferred by the NLC. In other terms, a receiver and manager may sell a land paid under the NLC by the charger corporation by private treaty pursuant to debenture and avoid the NLC's machinery, but the Kim Lin case has limited that convenience. Indeed, the Kim Lin verdict was a setback for the banking industry. In Kim Lin, the appellant was the licensed proprietor of those lands, and they established two legal charges over the lands in favour of the first respondent in order to protect the banking facility given to them. Both charges were registered in accordance with Section 108 of the Companies Act of 1965. The debentures given, among other things, that the first responder may appoint someone to be receivers and managers to the properties charged to it, and that such receivers and managers shall have right, among other things, to sell any of the appellant's asset for all properties, thereby charged at such price as they, in their absolute discretion, shall consider fit, having regard to the views and desires of the first respondent. Following that, the first respondent named the second, third, and fourth respondent as receivers and managers of the appellant in accordance with the terms of the debenture. Instead of securing a judicial lands under the NLC, the receivers and administrator sought leave to sell the lands from the court. The claimant went bankrupt and the liquidator was opposed to use the receivers and managers. A statutory fee under the NLC does not require any transfer of land ownership, and the charge only serves as a defence. As a result, the charges' right and powers are derived not from such properties, as none is vested in him, but rather from the applicable provision of the NLC. The NLC's rules pertaining to charges' right are intended to secure them, and the charger cannot waive them or contract himself out of NLC. As a result, the charger under the NLC cannot grant a chargee any power of sale by debenture, power of attorney, or otherwise, but the chargee must take proceeding to secure a judicial sale in compliance with the strict procedure. The chargee, especially banks and finance firms, are said to have welcomed the pattern of post-scheme linkage to aim to escape Kimlin and confine it to its peculiarity. Nonetheless, Kimlin remains important but in a weaker role. The essence and characteristic of these shares, as well as the right and powers associated with them, were compared. The common law mortgage is a conveyance of property as collateral of the payment of a loan, under which the value of the land is passed to the mortgagee and the mortgager is left with only an equal right to recover on payment, known as equity of redemption. The charger keeps possession of the property, and the chargee has the contractual right to execute the charge if the charger fails to pay. As a result, the privilege of the chargee are extracted from NLC. Based on this principle, the Supreme Court conclude that the charger cannot effectively confer upon his chargee a power of sale of charged land by debenture, power of attorney, or otherwise, and avoid NLC procedure for obtaining a judicial sale. That's all from me. Thank you.
Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad Lukman Al-Hakim bin Yusri. My metric number is 270089. Today I want to discuss about the legal analysis of Kimlin case. Based on the case, Kimlin have their protection from Section 176 of the Company Act 1965, Formation of Pengurusan dan Harta Nasional Berhad, and set up of a corporation debt restructuring commit CDRC. The section give a basic methods of weathering organization to reproduce and rebuild their wipe out issue without the need of going through the ordinary interaction of twisting up. At the point when the pipe was first sectioning, it was expected to permit an organization vigorously troubled by obligation, yet perhaps still practical, to convince its lender that it would be their greatest advantage to acknowledge a plan as a way to bargain their obligation to come to mutually beneficial end result. Two primary parts of Section 170C are included from example sub-segment and one sub-area 10. Sub-segment 10 is more commercial and debilitated organization will get the insurance of the court via a controlling request against any producing being taken by lenders. At the end of the day, with the controlling request, bank cannot make legitimate move against the organization, beside with leave of court. to outline a limiting request considered under Section 176 will control bank for understanding their security on which the credit office will allow or from reviewing the credit office. The standard is that the sickly organisation regularly act first by going to court under Section 176 to demand for a limiting request, so can is delay a planned course of action set up. Then again, Section 176(1) is utilized when organisation has a plan set up. However, look for a court authorization by expressing that its need to take the plan to the loan boss. A gathering of lender is then arranged under Section 176(1) so the organisation can advance the plan to look for the endorsement of 3/4 or quarter inwards of the bank. Specifically is at any rate 75% of the sum on. After accruing the extension greater part of the loan boss, the organisation will apply to the court again the endorsement of the HIB. When the court endorses the plan, the organisation need to hold up a duplicate of plan with the register of company. When the request is held up, all lender of the organisation will audibly notice the particular of the plan. Informative supplement A will clarify the various routes to acquiring insurance from loan boss under Section 1764. Other than that, in other hand, the court chose in the Kimling case have removed from the force of the debenture holder to sell handed properties by private deals. The court concluded that the offer of charge ground which have a place of defaulting corporate borrowers should rigorously follow the prejudice as segment 257 of the National Land Court 1965. The court chose the Kimling case has a somewhat modified the point of the banking having a debenture. For Kimling case has received a supervised consent land charge under NLC by charger allegation via private arrangement compliant with the debenture and bypass the apparatus given by the NLC. Appelling party was the entire owner specific ground and they made two lawful charges over the trains for the first respondent to get a financial officer consent to them and enroll under S108 of the Company Act 1965. A deed of debenture was executed by appellant for first respondent, which made boss of fee and drafting charges over all portable and affecting properties. The debenture was additionally enlisted under S Section 108 of the Company Act 1965. The debenture gave first respondent may choose any pupil to be the receiver and manager of the property charges. To such, receiver and manager will have ability to sell any of the appliance resource or properties along this line charge at such cost as they in their supreme activeness will think fit, having respect to prospectively and one of the first respondent. There was no express arrangement in the debenture distinctly the receiver and manager and lawyer of the appellant. Accordingly, the first respondent delegate the second, third, fourth and respondent as receiver as manager of the appellant compliant with the arrangement of the debenture. Rather than getting a legal offer authorized under the NLC, the receiver managed applied to the court for leave to sell the land. The appellant went into liquidation and the outlet went against the authorization of the receiver of the manager.
Hi,
My name is Tamil Mani Kumarasamy and my matrix number is 273275. Let us move to the last part of the presentation, conclusion. In conclusion, the Supreme Court in Kimlin went to the considerable lengths to clarify the main distinction between a common law mortgage and a contractual charge under the NLC. The extension and the characteristic of these shares, as well as the right and powers associated with them, were compared. Under the National Land Code NLC, no charger can confer power of sales by the way of a debenture or power of attorney or otherwise on a chargee, but the chargee must commence the proceeding to obtain a judicial sale in accordance with the strict procedures set out with NLC. Liquidation does not only terminate a receiver and manager agency for the company, it is also terminate its power on winding up as there is no estate for the receiver and managers administered. The common law mortgage is the conveyance of the law as a collateral for the repayment of a loan, under which possession of the state is passed to the mortgage and the mortgager is only left with an equal right to redeem on repayment, known as equity redemption. A fee under the NLC, on the other hand, take the form of the restriction on the title and does not entail the transaction of the ownership. Under the NLC, the contractual fee establish the legitimate interest in the chargee. The charger keeps possession of the property and the chargee has the contractual right to execute if the charger fails to pay. As the result, the privilege of the chargee are extracted from the NLC. Moving on to the recommendation, it seems that the legislature will need to decide ways to harmonize some aspect of our land law and company law in order to improve the productivity of the recovery process by the realization of land welfare. Moreover, the chargee is not required to convey to the liquidator the issue certificate of the title to the charged property and law in his custody. Furthermore, the NLC was amended to allow the private treaty sale of charged property, whether by a receiver and a manager or the fee. Last but not least, in inclusion of section 253 subsection 4 of the NLC in 2001 could have the effect of settling the Kimlin issue, as that clause requires the charger or chargee to nominate someone to perform its duties or work on his behalf. As things currently stand, it is anticipated that there will be a continuous departure from Kimlin in favor of chargee or institution of protected lending as long as the details are distinguishable from the Kimlin.